evening. Yeah, is that projecting? Is that okay? Okay, raise your hand if you can't hear me. My name is Alex Glover. I represent Victoria Sujata, who is an abutter to the 37 Interlaken property. I have crossed off large portions of what I was going to say because it has already been said. So if you'll bear with me, I'm going to skip through because I do not want the meeting to go longer than it needs to, and I know people don't need to hear anything twice. It is critical to understand the details of the difference between your current bylaw that requires special permit approval of a cottage era estate development and this proposal for site plan review. Attorney Mahoney talked about a number of these differences, and I won't repeat what he said, so I'm going to speak practically. Special permit, which is what you currently require, requires public notice that there's going to be a hearing on a request for this type of special permit or for this type of development. That notice has to be both by certified mail to abutters. It's actually people who are interested, so it's abutters and abutters of abutters within 300 feet. They get a letter. It's also publication in the newspaper. So there is public notice to everyone that someone wants to do one of these developments. Under site plan review, there is no public notice whatsoever. The application for the site plan review will appear on the planning board's agenda. So if you check the agenda before every meeting, you will know if Mr. Sheehan is going to develop his property under this proposal. Special permit that you currently have requires a public hearing. So that's whether it's before the planning board. Now your public hearing for this type of special permit is before the Board of Selectmen. It's a formal hearing, again, that's been advertised in the paper. There are more formal requirements that the board conducts the hearing, and everyone will have the opportunity to speak and can put evidence in about the pros and cons of whatever's being proposed, in this case, the cottage era development. Site plan review, again, there's no public hearing. It's a regular meeting of the board. There are no special procedural requirements that attach. If you've come to other board meetings, either the Board of Selectmen, the Planning Board, or other town boards, it's just one of the routine meetings where you run down the agenda and address all the items on it. Under special permit, the board can attach conditions, significant conditions. The board can also, if necessary, restrict or deny the request. Now, the request for a cottage era estate development is probably going to be a complicated request, right? So it's going to have a lot of components to it. The board will be able to go through all of those. Ultimately, if the developer will not change their proposal in a way that the board, under its regulation, feels is in the interest of the town, after listening to the public comment, that special permit application can be denied. Imagine what type of negotiations this board would have with a developer when the board cannot deny the application. How's that conversation going to go? If the board has no power meaningful power to deny it, then the developer can listen and can agree or disagree, make changes or not, but ultimately this board would have no power over this type of application. This proposal requires fewer votes of the board than your current proposal, and these are not all the differences, but the last one I'd mention is the difference in terms of enforcement. There are teeth to enforcing a special permit. So if a special permit was issued by the Board of Selectmen or the Planning Board and it is not followed, there are legal ramifications. If there are conditions in a site plan approval, the same ramifications do not exist. That is because, as Attorney Mahoney said, site plan review does not appear anywhere in the statutes of the Commonwealth of Massachusetts. It is simply a tool that is used by towns to help shape development. It is not appropriate. Whether you like what you've heard about this proposal, meaning the development or not, this is not an appropriate tool for development this massive and so out of character with the residential and the environmental area where it's proposed. Very quickly.
Alex, are you almost done?
Oh, this is my quick version. I am, very quickly. The Chief Justice of the Land Court says the scope of a board's review for site plan review is, quote, narrow. She says, if the proposal meets what's in the zoning ordinance or bylaw, the board must, this is a quote, the board must approve the site plan application, but can impose reasonable terms and conditions. Do you see that? Must approve it. You can't, of course, propose conditions. But ultimately, you can't deny it if the developer does not accept those conditions. One way to describe it is that the site plan review is an informational tool, where a building's going to be, where's driveway's going to be, collecting comments of various municipal authorities. It's not a regulatory tool. I'm going to flag and then sit down some questions that I had in this particular redrafted zoning bylaw. The site plan approval only applies to the resort uses. This residential use development with one structure per 3 acres, I do not read this proposal as requiring any approval for that whatsoever. So that massive part of the development, whether it's 30 homes or 60 homes, does not even fall under the site plan review, nor does the agricultural component. Resort site plan application requirements, that's just a list of what has to show on the plans. It doesn't say what requirements there are. How much traffic can you have? How many parking spaces do you need, etc. There's no requirements in here, like you would have under special permit. And then if you look at the site plan approval standards and criteria, again, it's mushy language. As to preserve to the greatest extent possible what's there. Incorporate measures that are adequate to prevent certain pollution, environmental issues, etc. Vague language, no specific standards. Attorney Silverstein said, and I think I've read it in the past, that let's leave it to the town meeting to decide. Well, the town will have a power and have a say over this development. Town meeting can decide. All the town meeting is to decide is whether or not the developer can do whatever they want. That's all they're going to decide. The town meeting is not going to decide about the merits of this proposal. What's going to the town meeting is yes or no, do you want to change the bylaw? So I would suggest and request that the planning board also issue a negative recommendation, that you recommend that this amendment not be made, and point out again that the developer has been doing this for more than a year, but he could have applied for a special permit under your current bylaw a year ago. To say the town's delaying him, I think, is unfair. Thank you very much.
Thank you.